I wait?
Just a minute, ma'am. Just a minute, ma'am.
Okay, sir. Okay. Good morning, sir. Muhammad Ali, sir.
Good morning, madam. Good morning, madam. Good morning.
Sir, don't call me as madam. I am your student.
Okay. Okay. Ayappan, sir. மேடம் உள்ளதா இருக்காங்க சார். நீங்க ஃபர்ஸ்ட் ஜாயின் பண்ணிட்டாங்கன்னா ஸ்டார்ட் பண்ணிட்டு இருக்கோம் சார்.
So good morning to all present here. So on behalf of JV College of Engineering Institution Innovation Council, so I welcome Dr. Rima Nelson, a former IPR head, assistant professor, Chitkara University Institute of Engineering and Technology, Punjab. So welcome you, ma'am.
Thank you, sir.
Happily welcome all students for celebrating World Intellectual Property Rights Day. It's our pleasure. It's welcome you, ma'am, on this occasion. So welcome.
Thank you, sir. Sir, shall I start?
Session, ma'am.
Okay, sir. Okay. First of all, I would like to thank my professor, Dr. Muhammad Ali sir, for providing this wonderful opportunity. Am I audible, sir?
Yes, ma'am.
For providing wonderful opportunity to present this presentation regarding innovation to intellectual property protection. Myself, Dr. Rima Nelson, Assistant Professor, Research, Chitkara University Research and Innovation Network, Curin, Chitkara University, Punjab. Moreover, I would like to thank your administrator, DMA and MMA group of institutions, Sister Hamlet ma'am. Then I would like to thank your principal, Dr. Rajkumar sir. Thank you all. And finally, I would like to thank my professor, Dr. Muhammad Ali sir. Now I will present my presentation. That is innovation to intellectual property protection. That is IPR, intellectual property right. Before going to intellectual property right, we have to know some basic terminologies about intellectual property rights. That is invention, discovery, and innovation. So what is invention? For example, I will give you an example, that is vacuum cleaner. Vacuum cleaner, initially, vacuum cleaner is invented by some inventor, right? So vacuum cleaner is the best example for invention. Then invention means a new product or process involving inventive steps and having the capability of industrial applications. So invention is the vacuum cleaner. Next, discovery means finding a new thing or property of a known material or article. So what is different from vacuum cleaner? So we are adding new feature or property in the vacuum cleaner. Initially, vacuum cleaner won't move from one place to another. We have to push or pull the vacuum cleaner. So we are adding new feature, that is automatically it will move from one place to another place. That is a new property we are adding to the vacuum cleaner. So the discovery has no technical effect without invention. So without inventing vacuum cleaner, the discovery has no effect, right? Next, invention. Is invention and innovation are same thing? Is invention and innovation is same thing? No, because see, this is the example. Discovery is first who is invented, that is invention or discovery. Next one is innovation. We have used X-ray is invented by some inventor, then we have used that in X-ray in medical field, that is innovation. That is we are increasing the accuracy or effectiveness, whatever it is. In vacuum cleaner, first invention is vacuum cleaner, then we are adding automatically moving from one place to another, that is discovery. Next, innovation. Initially, the accuracy of cleaning. Why we are using vacuum cleaner? For cleaning the dirt floor, right? So initially, the vacuum cleaner efficiency is 80%. Then after innovation, we are adding some features to increase the accuracy. So in our PhD also, what we will do for increasing the accuracy, that is not innovation. Invention, that is innovation. Only we are improving the accuracy, right? So innovation is different from invention. Innovation is the creation or development and implementation of a new product, process or service with the aim of improving efficiency, effectiveness or competitive advantage. So in our PhD, we are doing only innovation, not invention, right? So we all are eligible. Sir, am I audible?
Yes, ma'am.
Okay. So we all are eligible to apply patent, right? Because we all did some innovation during our PhD. So now you know the difference between invention, discovery, and innovation, right? So next, 4 pillars of research methods. What are all the 4 pillars? First one is creativity, innovation management, entrepreneurship, and future studies. These are all the 4 pillars of research methodologies. So in the first one, creativity. What does mean by creativity? For example, in vacuum cleaner is our creativity. Idea generation. What is idea generation? For developing a vacuum cleaner, we already have some idea. Then critical thinking. What is the difference between critical thinking and normal thinking? Critical thinking is nothing but scientific thinking, right? So it is a combination. Creativity is the combination of idea generation as well as critical thinking. Then innovation management. What does mean by innovation management? Innovation. Already we have innovated something, right? So innovation management is nothing but to filing the patent from starting some startups. Entrepreneurship is nothing but we will start some new startups. Next, future studies related to this innovation, right? Next, innovation is about 2 aspects. One is problem, another one is solution. So problems comes from the commercial world and surroundings. Okay, what is the problem behind vacuum cleaner? What problem we are going to solve to create vacuum cleaner? Basically, we are lazy people, right? So we need everything in a automatic manner. So we need to sweep the floor automatically. For that, we have to develop a new product. That product is vacuum cleaner. So problem is we want to sweep the floor. That is the problem, right? Solution. Next, solution. Solutions comes from the technical world. How we solve the problem? Using some development, right? So that vacuum cleaner is our solution. So innovation is nothing but the combination of these two is innovation. That is problem. Problem is real world problem. To develop or to invent a vacuum cleaner. What was the problem behind the vacuum cleaner? That dirt floor. That was the problem. What was the solution? Solution is nothing but to develop a vacuum cleaner. So problem plus solution is innovation. Again, innovation is defined as a process which may be achieved by to introduce new or improved goods or services, right? So innovation is nothing but to introduce new or improved goods or services, or to implement new or improved operational processes, or to implement improved organizational managerial process. So innovation is nothing but improved goods. What is meant by improved goods? Okay, what we have done in our PhDs, we are increasing some accuracy, or we are optimizing something, right? That is improved services. Next, to implement new or improved operational processes. So this is based on process. Next, to implement a new or improved organizational managerial processes. That is some step-by-step process, right? But the patent, I'll tell you later that. Then an idea or project is not an innovation unless it is applied in practice and put onto the market. So when when will be the innovation is useful? When it comes to the market. For example, you are having an idea to develop a vacuum cleaner. So that is your idea. Without coming to the market, that idea does not have any useful, right? So what you have to do, initially you have to think the idea, then develop the product, then apply patent. If you apply patent, next you have to develop a technology using that patent. Some startups you can develop. So when a product is useful, then it will comes to the market. At that time only the product is having some useful, right? So next, there are 4 types of innovations. Innovations are broadly divided into the following types. That is technological innovation, product innovations, process innovations, and management innovations. So we all are engineering backgrounds, right? So we can develop some technological innovations. Technological means actually now me and our professor Muhammad Ali sir is developing one technology using machine learning technique with IoT. That is a combination of 2 technologies. That is technological innovation. Then product innovation. Moreover, we are using some product also related to human health. That is diabetic powder. Next, some sarbat related product innovations. And also technological innovations, also sometimes product innovation. Then the technological innovations comes under product innovation. One of my student, ME student, have done one product, technological as well as product innovation. That is near-term prediction using some smart band, right? That smart band is a process innovation. What is meant by process? Step-by-step procedure to solve some problem. That is process innovation. But one thing, the patent rights won't give for some software. For software, the Indian Patent Office does not provide any patent rights because software versions will automatically, day by day, versions will change. So the Indian Patent Office won't provide the patent rights for softwares. Only they will provide hardwares. That is technological innovations, product innovations, but they will provide process innovation patent rights. Next, management innovation. What are all the management rules followed in some companies? For that also, they will provide patent rights. Next, creative process for problem solving. How we polish the innovation. Creative process of problem solving involves two different steps. One is divergent thinking, another one is convergent thinking, right? So first we have to know what is divergent thinking and what is convergent thinking. Initially, the same problem you have to think. That is, problem is what? The dirt floor. That was the problem. So from the problem, what was the divergent thinking? Divergent thinking means different ways of thinking, right? So how did you solve to clean the floor? So first you have to think, we have to assign some sweeper, or we have to clean by ourselves, or we have to develop a robot, or we have to develop some machine. That is different kind of thinking. So for problem, what was the problem? The problem is dirt floor, right? So dirt floor was the problem. So dirt floor was the problem. Next, divergent thinking. Divergent thinking is nothing but different thinking. Next, idea generation. So we have some different thinking. What are all the thinking? Sweeper, allotment, or we have to create, develop some machine, or we have to develop some robot, like that. Different types of thinking came in our mind. Finally, idea generated. That is, we have to develop one machine, right? So we are next, convergent thinking. What is the convergent thinking? Our idea is to develop a machine, that is vacuum cleaner. So convergent thinking is to develop a vacuum cleaner. What are all the things we need to follow, right? That is convergent thinking. To achieve this goal, what are all the process we have to do behind to achieve the vacuum cleaner, right? That is convergent thinking. So selection of ideas. So how the vacuum cleaner has developed? Initially, it will scan the floor, right? For scanning, we have to use one camera, whether the floor is clean or dirt. So first we need a camera, that is scanner, right? So it will scan the floor, whether the floor is clean or dirt. Next, we have to write some fuzzy. Initial vacuum cleaner is based on fuzzy rules only. Only 4 rules are applied in the vacuum cleaner. What are all the 4 rules? If the floor is dirt, then clean. This is the first rule. Second, if the floor is clean, no need to do anything. If the floor is clean, you just turn left and scan the floor. That is the third rule. Like that, only 4 rules are developed. Only 4 rules are used to develop the vacuum cleaner, right? So we have some selection of idea. First selection is vacuum cleaner scanner. That is one camera. Camera is fixed. Then based on the fuzzy rules, it will do the operation. For that, they have used fuzzy rules. That is the second thing. Based on the fuzzy rule, the actuator will clean the floor. Totally 3 things are available. So to achieve or to develop the vacuum cleaner, the convergent thinking is important, right? So what are needed? Some hardware as well as some software kind of things are needed. So that is selection of ideas. Finally, apply these ideas to develop a vacuum cleaner. That is innovation. What is the innovative product? The vacuum cleaner is our innovation. Problem representation is nothing but dirty floor. Next, different divergent thinking is different thinking to solve the problem. Then from that idea generation is what is our idea? What is our objective? To develop a vacuum cleaner to clean the floor. That is machine, to develop a machine. Next, convergent thinking. Convergent thinking is nothing but to develop the vacuum cleaner. What are all the rules or what are all the hardware and software needed to develop the vacuum cleaner? Finally, innovation is vacuum cleaner. Next, open innovation. First is idea generation. Ideas generated from outside the organization or inside the organization. Then selection of ideas, then execution, then commercialization. Commercialization is nothing but we have to take the product. Initially, we have to get the patent rights, right? See, initially develop new ideas. Develop new ideas, select successful ideas, because in our college we have submit several ideas to our patent office. They will select best ideas from the patents from our uploads, right? Select successful ideas, then they will tell your idea very good, so you have to submit the prototype. If we submit the prototype, start some startups. So for example, for the vacuum cleaner, if I have some idea, then I have to give the prototype. Prototype is nothing but just a simple model. We have to submit the model to our patent office. They will provide some funding minimum 2,50,000 they will provide. So for that we can, from there we can develop some startups. So from the idea to the vacuum cleaner come to the market. Without come to the market, that idea does not give any useful thing in our current world, right? This is the basics about innovation, invention, as well as discovery. Next, intellectual property. Intellectual property refers to creations of the mind, such as inventions, literary or artistic works, designs and symbols, names and images used in commercial world, right? So to whom they have provided the intellectual property right? Creations of mind, such as inventions, literary, artistic works, designs and symbols, and names and image in commercial world. Next, importance of intellectual property rights. Avoid duplication of research. What is meant by avoid duplication of research? Any idea? If anybody having intellectual property rights, then no one can copy their work. Nowadays we are having some plagiarism act are there, right? So if we have patent rights, then no one can copy your work. Then we can't file a published patent again. Sometimes somebody filed one patent, the same patent can be copied from some other person, and again he or she will file. This won't happen in this IPR. Then transferring innovation as public property. You all know about invention and innovation. So invention to public property, right? So it comes to the public. Then latest development of technology, it is the award to the inventor. So reward as exclusive right. This is the reward for the inventor. It provides profits. Profits means if a product comes to the public, then the public will provide some amount to the inventor, right? Because the inventor having IPR, intellectual property rights. Next, indicator of achievements. Next, this is the indication. IPR right is the indication of achievements. Next, encouragement for improvement of technologies. It will encourage the improvement. What is actually IPR? We are not inventing anything new. We are innovating, right? Innovating means what? We are increasing the accuracy, or we are increasing the effectiveness of the work, whatever it is, right? We are not doing anything new invention. Just we need some improvements in the existing technology. For that, we can apply intellectual property rights, right? Next. Significant, again, importance of IPR. It is commercial scale, commercially exploited, legal proceedings. What is meant by legal proceeding? Legal proceeding means if I am having if I am having patent rights, then without my permission, no one can use that, right? If they will use means they have to provide some amount for me through Indian Patent Office. Then preventing competitors, expanding market share, market value, tax saving, then corporate identity through a trademark. Next, this is a very, very important thing, that is tools to protect intellectual property rights. One is patents. We all only know patents, right? In patents also there are 6 categories available. First one is patents. Patent is usually called utility patents. Then design patents, trademarks, copyrights, semiconductor integrated circuits, layout design, and geographical indication. We will see these things one by one in future slides, right? So initially patents. Patents is nothing but utility patents. This is exclusive privilege or right to the inventor. It is granted by the government to the patentee. So who will provide this? It is granted by the government to the patentee. For 20 years from data filing. So valid for utility patent is from the data filing to only 20 years. If we want to extend the patent, it will extend only 5 more years, right? So if we file a patent, then how many years it will take to grant? Minimum 2 years to grant a utility patent. It is used for commercial gain. Then in consideration of full disclosure of his or her invention. It is a territorial right and not worldwide. So what is meant by territorial right? This IPR, if we are filing patent inside India, then this patent right only applicable inside the India. So this is the territorial region. Territorial means in India only it will be applicable. In US, somebody can copy our work. Only inside India it is right. No one to copy the work. Next, innovation die one day. Already I have told that only 20 years is valid after filing, right? So it will die after 20 years, right? So when it will die? After 20 years. It can be extended plus 5 years, right? This is called innovation die period. Next is very, very important. Patents. Want to file patent application in India? What to do? What forms should I fill? How much is the fee? This is because initially I don't know anything about patents. Nowadays I am very much familiar about patents because previous semester I have evaluated nearly 200 patents. So I know some basic ideas about patents filing, right? So when we file a patent, we have to submit Form 1, Form 2 and Form 5. Only 3 things we have to submit. First, Form 1 consists of details of application and applicant. So in the Form 1 consists of only details of application and applicant. For this, fee need to be paid. For that, for Form 1, we have to pay the amount of fees. How much amount? 1,600 we have to pay. While filing a patent, initial amount is 1,600. So form 1, we have to fill the application and applicant. Who is the inventor? Who are all the member of that innovation? Like that we have to fill. Sir, any background noise is coming? Some construction work is going here. Any background noise is coming, sir? Sir, am I audible?
Oh, that is not visible. It's audible, ma'am.
Is any interruption is coming from my side, sir?
No, ma'am. That's not disturbing me.
Okay, sir. Okay, so we have to submit form 1, form 2 and form 5 while filing a patent. Form 1 consists of details of application and applicant. So we have to fill the applicant. Applicant is nothing but the innovator and the team members details. Next, form 2 consists of details of invention, title, background of invention, particulars of drawings, brief description of drawing, brief description of the invention, clients and abstract, right? So form 2 consists of these details. So for this form 2, we no need to pay any fees. Next, form 3, details of foreign filing of similar invention. If you want to file the same patent, you have to submit different application. In the initial stage, no need to pay any fee, right? In future, you have to pay some amount. Next, declaration as inventorship. That is, for this also fee is not required. Next, form 18, request for examination deemed to be withdrawn. See, without filing, we can't move to the request for examination. I will tell you the step-by-step procedure in future slide. Right. Next, fees for e-filing in rupees. For a natural person, form 1 you have to pay 1,600. Other than natural person, for example, company means they have to pay nearly 8,000 for a patent. Patent means utility patent. Next, form 2. What does form 2 consist of? Form 2 consists of related to our research work. Research work is nothing but innovation. Form 18 consists of, what is Form 18? Form 18 is nothing but this examination. Initial, we have to request the Indian Patent Office to examine our patent. These are all the procedure happen behind the patent. Initially, we have to file the patent. Then, I am the innovator, right? I am going to file the patent. Next, I have to send the request to the Indian Patent Office, kindly examine my patent. What does the examination consist of? There are totally 2 examinations available. One is formal examination. What does mean by formal examination? Formal examination is nothing but if all the forms are clearly written or not. Wait a minute, sir. Examination consists of 2 types, that is formal examination, another one is technical examination. Formal examination is nothing but whether the innovator submit the forms properly or filled the forms properly. The second step consists of technical examination. Technical examination is nothing but whether the technology is written properly or not, whether the flow is proper or not, like that they will check. That is formal as well as technical. So there are 2 types of examination. Next one is first examination report. We will request the Indian Patent Office to examine our our application. So they will start to examine our application. Then first examination report. So you have to think, initially you have communicated the paper to some journal, right? So what it will happen, the reviewer sends some comments to us. While evaluating, they have some comments. So they have sent the comments to us. Why they have sent the comments? We have to reply that comments, right? Like that, the Indian Patent Office sends the examination report to us. So list of objections are communicated to the applicant. They will send the comments is nothing but objections are communicated to the applicant. Next process, first filing is the first step. Second, we will request the Indian Patent Office to examine our patent. Next, third step is they will send the examination report. Examination report is nothing but that comments from the Indian Patent Office related to our patent. Next, examination on reply of the applicant. What is the examination on reply of applicant? We have communicated the paper. The reviewer sends some comments to us, right? So what we will do, we will write a reply and again send to the reviewer. So like that, we will write the reply and again communicate to the Indian Patent Office. Next step is hearing. What is meant by hearing? The technical discussion on pending objection between applicant and hearing officer. So in paper publication, we no need to in publication also we have to tell these are all the things we are communicated to you. This is the reply for each and every comments, like that we will tell. Like that in hearing also, technical discussion. They will raise many questions and they will send a question to us. We will reply the reply regarding to the questions. That is, we have to answer the technical questions. So these are all very, very important. First, for utility patent, it will take 2 months for file. Next, within 48 months, we have to send the request to the patent office to examine our patent, right? Then they will send the report. Finally, after hearing, they will grant. If the patent is good, then they will grant. Otherwise, they will reject our patent. These are all the sequence followed behind the patent filing. First is filing. Next, we will request the patent office to examine our patent. For that, we have to pay 4,000 rupees, right? Then they will send the first examination report to the innovator. Next, examination on reply. We will send the reply to the questions. Next, hearing. They will ask some technical question. We will discuss. This is not directly involved to the inventor. They will send the question to us, like a reviewer comments. Finally, they will grant the patent. For granting utility patent, it will take how many years? 2 years it will take. Next, design patent. First, we have discussed about patents. Patent is nothing but utility patent. Now, design patents. What is meant by design patent? See, design means only the features of shapes, configuration, pattern, or ornament, or composition of lines, or color, or combination thereof. Okay, so it is nothing but it is a shape, only shapes, front view, top view, like that we have to submit to the Indian Design Office, not Patent Office, Indian Design Office. In IPR website, there are several branches available. For if you want to apply utility patent, means you have to click patent. If you want to apply design patent, then you have to click design. Right. So in this example, see, the shape of this shoe heel, right? This is the shape, then shape of this mobile phone. So we have to take a picture. 6 views are available: top view, front view, isometric view, back view. Several views are there. 6 views. We have to take a snapshot and send it to the design office, Indian design office, right? Next one is trademark or brand name. Third one is trademark or brand name. Trademark or brand name. It is a visual symbol which may be a word, name, symbol, brand or device, numeral or combination of colors used by one undertaking on goods, right? So we have to take the trademark. Trademark is also one type of property right? We have to take this trademark for these combination: visual symbol, that is a word. See, this is the example, Intel Inside. This is the trademark. Sony TV, then Coca-Cola, Nokia. These are all the trademarks. If you want to start a company, then you have to apply some trademark, right? So a trademark, popularly known as brand name, in layman's language, is a visual symbol which may be a word, signature, name, device, label, numerals, or combination of colors. This is the combination of colors used by one undertaking on goods or services or other articles of commerce. Commerce means commercial application, to distinguish it from other similar goods or originating from different undertakings. So trademark is nothing but combination of colors or combination of different things, colors and fonts. This is the word, signature, device, numerals, or combination of colors. These are trademarks. Next one is copyright. Copyright or author's right is a legal term used to describe over their literary or artistic work. So copyrights are provided to the literary work. Literary work means what? For films, they have written some scripts, right? So for that also they have applied copyrights, or some software version by copyright. Copyright provides its holder to restrict. What is the use of this copyright? Right to restrict unauthorized copying and copyright work, but we have to give proper reference for this copyrighted work, right? So what we have to do, we can copy the work, but we have to provide the proper reference for that. For that, this copyright is used. Right to restrict unauthorized access. So what is the difference between authorized and unauthorized access? Authorized means we can copy the work, but we have to give the proper reference. But without providing proper reference, we can't copy the copyrighted work. Next, works converted by copyright range from books. So for what purpose we have to apply copyright from books? Books means they have written some new things in the books. For that, we have to apply copyrights. Then music lyrics or music, different music. For that, we have to apply. Then paintings, sculptures, films, computer programs. Computer programs is nothing but softwares. Then databases. What does mean by databases? In online, there are several repositories are available. So by using that example, Kaggle repository, UCI repository, many repositories are available. While using the data set, we have to use, or we have to introduce the names in our paper, or we have to give the proper reference for that database, because that database already having some copyrights. Then advertisements, maps, and technical drawings. For that, they have provided some copyrights, right? Next, term of protection granted. So what is the dying period of copyright, or what is the valid period for copyright? Life of the author plus 60 years. So this much is, for example, if an author have written, I have written one book, right? So I have applied for copyright, then how many years it will be available? Up to my death plus 60 years. After that, anyone can copy that content, right? This is the dying period of copyrights. See, these are all the examples for copyrights. What is covered by copyright? Literary work. Literary work is nothing but books, films, scripts, dramatic scripts, then musical lyrics, artistic sound recording, whatever it is. These are all the copyright contents, right? So literary, films, dramatic, musical, artistic, and sound recording. Next. Okay, semiconductor integrated circuits layout design. This is the fifth intellectual property right, and they have introduced this in previous year 2022 only, right? Semiconductor integrated circuits layout design. What is this intellectual property right? So if you want to apply intellectual property right related to chips means what? That semiconductor circuits, then you have to apply SICLD patent rights. Semiconductor integrated circuit means a product having transistors and other circuitry elements inseparably formed or inside semiconductor or insulating material designed to perform an electronic circuitry function. So if we have some layout related to circuits, then we can apply this SICLD. So sometimes we will develop a chip and we will embed some programs with the chip, means we have to get the patent rights for SICLD, right? And also if you develop some different layouts for some circuits, right, then you can apply this kind of patent rights. SICLD is an important IPR for protection of products with fast changing technologies such as electronic gadgets, computers, etc. So this copyright is for fast changing technologies. See, these are the SICLD chips. So if you have any kind of circuit design also, you can get, see, layout of transistors and other circuitry elements include lead wires connecting such as elements and expressed in a manner in SIC. So if you have any circuit related work, new work, innovative work, innovation, your circuit will increase the efficiency, or your circuit will give this much accuracy, or this much, something you have to improve from the existing work, then you can apply this SICLD patent. Next, geographical indication. This is the final IPR right. Geographical indication is an indication that identifies a product that have a specific geographical origin and processes, qualities, or a reputation due to that origin. It cannot get grant to an individual. It is a right to a specific area. So we cannot get the grant. So geographical indication cannot give patent right for a single person, because this is based on a specific area. For example, Madurai Malli, we can't get a patent right for that Madurai Malli because it is a specific region range, Madurai range patent right. So cannot get grant to an individual. So a single person cannot get this geographical indications patent right. So cannot get grant to an individual. It is a right to a specific area. So place name used to identify the source of origin. So based on the place name, it will provide the patent rights. See, Banaras Sari, Nagpur ki Santry, Agra ka Beta, these are all the examples for geographical indication. So we can't apply geographical indication patent rights because the patent rights won't provide for an individual, right? It is a right to a specific area. Next, geographical indications. Geographical indications are place names used to identify the source of origin and quality, reputation, or other characteristics of products. So, Kolhapuri chappals, we can't get the patent rights for this Kolhapuri chappals because this is also a region-based right? So, Kolhapuri place related the region. The group of people only get this patent rights, geographical indication rights. Then Kanjipuram silks. So Kanjipuram people only get this rights. Then various intellectual property can be obtained in a single product. So there are different IP can be obtained in a single product. See, this is the pressure cooker, right? So constructional features, working features, right? So for that we have to apply the utility patent. Patent is nothing but utility patent. Constructional features. Next, design. What is design patent is? Design patent. To whom will apply the design patent? Design is nothing but the front view, top view of the product. So we can apply patent right for construction features. Construction features means working process, step-by-step procedure. If we know the working condition, then we can apply the the innovator, new innovator can apply the patent, utility patent rights. Then design. You all know about the design, only the structure of the cooker. If we know the structure of the cooker, then we can apply design patent. Trademarks. Trademark for this logos and names. This Premier is the logo for this pressure cooker, right? So we can apply trademark for this Premier. Next, copyright. This catalog or booklet. They have some booklet. For that, they will get the copyright. Copyright is the nothing but no one can copy the catalog of Premier pressure cooker. So a single product can get different intellectual property rights. Next, again the second example, multiple IPRs for one product. So again I am saying for a single product we can get different intellectual property rights. Totally 6 types of intellectual property rights are available, right? So first, technology. So for technology means we will apply patent, utility patent rights. Patent is nothing but utility patent. Next, content some booklet. For that we will get the copyright. Next, shape, design, colors, whatever it is. For that we will get the design patent. Next, trademark. This Samsung is the trademark. So for this we can get the trademark. We will get SICLD also because this mobile phone having some chips, semiconductor related work is available, right? So for that we will get this semiconductor integrated circuit design patent, SICLD patent. So for this, how many patents we can apply? Utility patent, design patent, trademark, copyright, confidential secret, as well as SICLD. We can't get that geographical indication because geographical indication patent cannot be applied by a single person or individual person, right? So without that geographical indication, we can get 5 patent rights for a single product. Next, Again, same inventive step. If you want to apply a patent, you have to create some inventive step. Inventive step is nothing but new step. Already we have done in our PhD to increase the accuracy, to increase the effectiveness of the system. Many things we have done. Usually what happened is, here people are doing some application based work. In our place, we are doing the technical based things, but we are not applying patent rights. Here, each and every sweepers or some persons also having some design patents, but we people does not have even a design patent, utility patent, nothing we don't have. So here after this presentation, you all will apply some patents, at least design patent. Design patent is very, very easy patent. Within 6 months, we will get the grant, right? Next, inventive step. Finally, I will show some very, very simple design patents. Then only you can apply. Each and every student will apply design patent. I will tell you the basic things regarding design patents. Now, inventive step. Inventive step is nothing but new thing, something new. Very little. See, here each and every sweepers or floor cleaners, whatever it is, everyone is having some design patents. Then why you can't apply patents? We people are not involving in that patents, because patent is very hectic to apply like that, we are thinking. But it is not like that. Each and every, even a single BE, all BE students having a single, at least design patents in Chitkara University, right? So you all apply at least one design patent before leaving your organization. Organization means UG people or PG, whatever it is. Just apply at least design patent. Next, inventive step means feature of an invention, just a new step for invention. It involves technical advancements as compared to the existing knowledge. Already I have discussed, inventive step is nothing but just increasing the accuracy or effectiveness of the already invented product, right? So it makes the invention not obvious to a person skilled in the art. Okay, novelty. Actually, what we will do here is, if anybody have applied a patent through patent office in Chitkara University, immediately we will check the novelty, whether anything is new or not. For that, we will check. If anything, then if it is new, then we will send this to attorneys. Attorneys means lawyers. They will check whether the work is new or not. If it is new, then they will file a patent. Otherwise, the attorneys will send the prior art search. What does mean by prior art search? That is the important thing for filing a patent. Prior art search is nothing but existing work. We will write a literature review in our paper, right? It's similar kind of thing is prior art. Prior art is nothing but existing work, whether our patent is new or not. If it is new, then prior art search is not available. Prior existing work is not available. Immediately, attorneys will file the patent. If it is already available, then attorneys will send the, see, these are all the works already published, already filed, like that they will send to us. From the prior art search, we will again refine our work. Then again we will submit our patent to the to our Chitkara University website, right? Then one more thing, Chitkara University is the #1 position for filing design patent in previous year, 2022. Chitkara University is the first position in India for filing patents. Next, non-patentable inventions in India. So, see, there are several non-patentable inventions are also available in